Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. Divorce laws, judicial discretion, and local court procedures vary significantly by state and jurisdiction. The historical trends and case studies discussed are intended to provide context and perspective, not to serve as a substitute for the counsel of a licensed attorney or a qualified professional in your specific area. Always conduct your own due diligence and consult with the legal expert regarding your individual circumstances. In 1920, if a man in the United States wanted a divorce, he didn't just need a reason. He needed a villain. For nearly two-thirds of the 20th century, the American legal system operated under a fault-based regime where one spouse had to prove the other was guilty of a moral or legal transgression, adultery, extreme cruelty, or willful desertion. If you couldn't prove a crime, you couldn't get out. Fast forward to 2026, and the landscape has shifted so violently that the primary challenge for men is no longer getting out of a marriage, but surviving the financial and parental exit. Today, roughly 40% of first marriages in the U.S. end in divorce, but the rules of engagement have changed from moral warfare to high-stakes asset tracing and algorithmic mediation. Plus one. Consider this. In the mid-1900s, alimony was almost exclusively a lifelong pension paid by men to women, rooted in the tender years doctrine which assumed mothers were the only fit parents for young children. By the 2020s, the emergence of the silver splitter demographic and the rise of female breadwinners has led to a reality where, in some jurisdictions, men are increasingly the ones seeking spousal support, while 50-50 shared custody has become the default starting point in several states. We are currently living through a total inversion of a century's worth of legal precedent. This deep dive masterclass is designed to solve the most pressing problem facing men in 2026, the information gap. We are going to bridge the distance between the outdated horror stories your father might have told you and the high-tech, data-driven reality of the modern family court. By the end of this series, you will understand the historical evolution of your rights, the shift from fault to no fault, and how to navigate a system that is increasingly prioritizing parallel parenting over traditional custody battles. To understand where we are, we have to look at the staggering data of the last 100 years. In 1900, the divorce rate was approximately 0.7 per 1,000 people. By the peak in 1980, that number had skyrocketed to 5.3 per 1,000, largely due to the no-fault revolution, ignited by California's Family Law Act of 1969. This change wasn't just a legal update, it was a social earthquake. Before no-fault, a man could be trapped in a dysfunctional marriage indefinitely if his wife refused to grant him a divorce, or if he couldn't produce evidence of her misconduct. Conversely, if a man was found at fault, he could be stripped of his assets and access to his children as a form of judicial punishment. Plus one. The shift to no-fault divorce theoretically leveled the playing field by removing the need for a guilty party. But for many men, it introduced a new era of unilateral divorce. This meant that a marriage could be ended by one partner without the consent of the other, often catching the husband off guard and leaving him in a reactive position regarding his finances and fatherhood. We see this reflected in historical trends. As the requirement of fault vanished, the duration of litigation decreased, but the complexity of asset division grew. In the early 20th century, the legal philosophy was simple: protection of the weaker party. Because men held the vast majority of economic power and women were often legally and socially barred from the workforce, alimony, originally called permanent maintenance, was a tool of social survival. If a man left, he paid for life. However, by the 1970s and 80s, the Supreme Court case of Versus or 1979 struck down laws that required only husbands to pay alimony, ruling them unconstitutional under the Equal Protection Clause. This was a watershed moment for men, establishing that gender could not be the sole basis for financial obligations. Moving into the 1990s and 2000s, the focus shifted from who is to blame to what is in the best interest of the child. This sounds noble, but for decades, the best interest standard was often interpreted through a lens of gender bias that favored maternal custody. Case studies from this era show a pattern of fathers being relegated to every other weekend visitors. However, the data from the last 10 years shows a massive correction. As of 2026, states like Kentucky, Florida, and Arizona have passed laws making equal shared parenting the rebuttable presumption, meaning the court starts with the assumption that a 50-50 split is best for the child unless proven otherwise. For the modern man, the challenge has moved into the digital and psychological realm. We are seeing a 2026 trend where mental health literacy is becoming a weapon or a shield in the courtroom. It is no longer just about who has the higher salary. It is about who can demonstrate emotional regulation and co-parenting communication. The win-at-all-costs strategy of the 1990s is being replaced by strategic restraint. In fact, recent data suggests that men who engage in high-conflict litigation in 2026 often face judicial fatigue, where judges exhausted by backlogged dockets penalize the party they perceive as the primary agitator. We also have to address the digital paper trail. A century ago, hiding assets meant burying gold in the backyard or keeping a secret ledger. In 2026, asset division involves forensic analysis of cryptocurrency wallets, digital gift card hoarding, and tracing offshore neobank accounts. The irony of the modern era is that while it is easier than ever to hide money, it is also easier than ever to get caught. Blockchain technology, once thought to be the ultimate tool for privacy, now provides an immutable record that forensic accountants use to dismantle claims of poverty. The potential outcomes for men today are vastly different than they were even 20 years ago. We are seeing the rise of step-down alimony, where support is designed to be transitional rather than a life sentence. We are seeing the death of the tender years doctrine in favor of parallel parenting, a model designed for high-conflict couples where parents minimize direct contact to protect the children and themselves from further litigation. This masterclass is going to break down these historical shifts into actionable insights. We will examine how the starter marriage of the early 2000s gave way to the delayed commitment of the 2020s, and why that matters for your prenuptial or postnuptial strategy. We will look at the data behind gray divorce among those over 50, which has doubled since the 1990s, creating unique challenges for retirement accounts and Social Security benefits. The problem we are solving today is the legacy of fear. Many men approach divorce with a 1950s mindset, I will lose everything, or a 1980s mindset, I have to fight for my life. Neither is accurate in 2026. The modern system is a bureaucracy of data, and the man who wins is the one who understands the history of these laws and the current trajectory of the courts. This is your guide to navigating that century of change, moving from a position of vulnerability to a position of informed strategy. We are moving away from the War of the Roses and into the era of the smarter settlement. To understand how to navigate a smarter settlement in 2026, we first have to deconstruct the legal architecture of the mid-20th century that created the modern male anxiety surrounding divorce. Imagine a man named John in 1955. John lives in a suburban neighborhood in Ohio. If John and his wife Mary reach a point of irreconcilable differences, the law doesn't care about their feelings. In 1955, Ohio, like almost every other state, is a fault-only jurisdiction. For John to get a divorce, he has to prove in open court that Mary committed a specific sin. He needs witnesses, photographs, or telegrams. If he can't prove adultery, extreme cruelty, or 3 years of consecutive abandonment, John is legally bound to that marriage forever. This created a massive underground market for staged scenes and perjured testimony, just to secure a legal exit. Now, compare John of 1955 to David in 2026. David lives in Austin, Texas. He doesn't need to prove Mary did anything wrong. He can simply file for divorce based on insupportability, which is the Texas version of no fault. But here is where the complexity begins. While the barrier to entry for divorce has vanished, the barrier to an equitable exit has become a data-driven maze. In 1955, the assets were simple: a house, a car, and a pension. In 2026, David is dealing with unvested restricted stock units, a diversified 401k, a family health savings account, and perhaps a small stake in a cryptocurrency startup. The shift from moral fault to mathematical equity is the most significant historical trend men must grasp to survive this process today. Let's look at the evolution of alimony, or what is now more commonly referred to as spousal maintenance. Historically, alimony was rooted in the concept of the husband's duty to support. Case studies from the 1940s show that if a man was the breadwinner, he was often ordered to pay permanent alimony until the wife either remarried or passed away. It was a life sentence for his paycheck. However, as we moved into the 1970s, the feminist movement and the entry of women into the workforce began to shift judicial thinking. The landmark 1979 Supreme Court ruling in versus or was the catalyst that changed everything for men. The court ruled that gender-based alimony laws were unconstitutional. This set the stage for the 2026 reality, Alimony is no longer a gendered right. It is a financial bridge. In 2026, judges in the United States increasingly utilize the concept of rehabilitative maintenance. This is a step-by-step approach where support is granted only for the period necessary for the lower-earning spouse to become self-sufficient. For example, if David's wife stayed home for 10 years, the court might grant her maintenance for 3 years while she completes a degree or gains certification in a new field. The data shows that in 2026, long-term or permanent alimony is becoming a rarity, typically reserved for marriages lasting over 20 years or cases involving significant disability. Understanding this historical trend allows a man to approach negotiations not from a place of, how much will I lose forever? But, how do we calculate a fair transitional period? Next, we must examine the radical transformation of child custody, which has historically been the most painful area for men. For much of the 20th century, the tender years doctrine was the reigning legal philosophy. This doctrine suggested that during a child's early years, the mother was the naturally superior parent. Between 1920 and 1960, a father's role was often reduced to that of a financier. He paid child support, and he saw his children on alternating holidays if he was lucky. The psychological toll on men during this era was immense, as they were effectively erased from their children's daily lives by judicial fiat. But look at the shift as we move into the 2000s and eventually 2026. Scientific data regarding child development has completely overturned the tender years doctrine. Research now overwhelmingly supports the idea that children with two actively involved parents have better emotional and academic outcomes. This has led to the shared parenting revolution. Imagine a father in 2026 named Michael. In 2010, Michael might have struggled to get anything more than a 60-40 split. In 2026, in over 20 states, Michael starts with a presumption of 50-50 custody. This means the burden of proof has shifted. It is no longer Michael's job to prove he is a good father. It is the other party's job to prove that his involvement would be detrimental to the child. This is a monumental victory for paternal rights that has been a century in the making. However, with 50-50 custody comes 50-50 responsibility. In 2026, the court looks at the parenting plan with microscopic detail. This isn't just about who has the kids on Tuesdays. It covers everything from who makes decisions about orthodontic care to which parent is responsible for transportation to extracurricular activities. The successful man in a 2026 divorce is the one who presents a proactive, comprehensive parenting plan before the court even asks for one. This shift from fighting for rights to demonstrating capability is the hallmark of the modern era. Then there is the financial evolution of community property versus equitable distribution. This is a technical area where many men lose significant ground because they rely on myths rather than current law. There are two primary systems in the U.S. In community property states like California or Washington, everything earned or acquired during the marriage is generally split 50-50. In equitable distribution states like New York or Florida, the split isn't necessarily 50-50. It's what the judge deems fair. Historically, fair was a subjective term that often favored the spouse with fewer assets. In 2026, fair is increasingly defined by sophisticated software. Legal professionals now use complex algorithms to balance tax implications, future earning potential, and the liquidity of assets. If you are a man in 2026 with a high net worth portfolio, your battle isn't just about the dollar amount, it's about the nature of the assets. For instance, $500,000 in a house is not the same as $500,000 in a brokerage account due to capital gains taxes and maintenance costs. The 2026 approach requires a man to think like a chief financial officer. You have to analyze the long-term burn rate of a settlement. Historical trends show that men who focus only on the immediate cash out often find themselves in financial distress 5 years later because they didn't account for the tax-deferred nature of the assets they kept. We are also seeing the rise of the silver divorce phenomenon. In 1920, it was almost unheard of for a couple over 60 to divorce. By 2026, the divorce rate for those over 50 has reached historic highs. This creates a specific set of problems for men regarding retirement. In the mid-20th century, a man's pension was often his alone. Today, qualified domestic relations orders, or QDROs, allow the court to split pension and 401k assets directly at the source. This means a man who spent 40 years building a retirement nest egg may see half of it diverted before it ever hits his bank account. Navigating this in 2026 requires understanding Social Security offsets and how to protect separate property, assets you brought into the marriage, through diligent record-keeping that spans decades. The century of change has moved us from a system of moral judgment to a system of social engineering and financial accounting. The men who thrive in this new landscape are those who recognize that the old scorched earth tactics are not only outdated, but financially suicidal in an era of high-cost legal fees and transparent digital assets. We are moving toward a model of high-functioning dissolution, where the goal is to preserve as much capital and parental influence as possible through strategic cooperation rather than blind litigation. But even with the law shifting toward equity, there is a hidden trap that many men fall into before they even step into a courtroom. It is a trap that didn't exist in 1955, but in 2026 it can destroy a case in a matter of seconds. It involves the way your digital identity and your shadow data are being harvested by opposing counsel to build a psychological profile of you that the judge will see long before you ever speak a word. In the next part, we are going to dive into the digital battlefield and how your smart home, your fitness tracker, and your search history have become the most powerful witnesses in modern divorce. We will explore how to protect your digital perimeter and why the first 30 days of a 2026 divorce are more critical than the trial itself. The digital perimeter of a 2026 divorce is not just about your social media posts or your private emails. It encompasses the entirety of your digital footprint, which in the modern era acts as an unintentional biographer of your lifestyle, your parenting habits, and your financial expenditures. In the 1980s, a private investigator had to physically follow a subject with a long lens camera. Today, a digital forensic expert can reconstruct a man's entire daily routine using metadata from a smart thermostat, a Peloton bike, or a connected vehicle. This transition from physical surveillance to digital data mining represents one of the most significant shifts in how legal cases are built in the United States. Imagine a man named Robert in Seattle. It is 2026, and Robert is entering the early stages of a high-conflict divorce. Robert believes he is being cautious because he hasn't posted on Instagram in months. However, Robert's home is equipped with a comprehensive smart ecosystem. During the discovery phase, the opposing counsel subpoenas the logs from his smart doorbell and his home security system. These logs don't just show who came to the door. They create a time-stamped record of Robert's movements. If Robert claims in his custody deposition that he is home every night by 6 p.m. to assist with homework, but the smart lock and garage door logs show he consistently returns at 9 p.m., his credibility is effectively neutralized before he ever takes the stand. This is the reality of the shadow data witness. In 2026, the first 30 days of a divorce filing are known as the preservation window. Under United States legal standards regarding electronically stored information, or ESI, there is a strict duty to preserve evidence once litigation is reasonably anticipated. Many men, acting out of panic rather than malice, make the mistake of deleting old text threads or clearing their browser history in those first few weeks. Historically, this might have gone unnoticed. In 2026, the use of forensic software like Celebrite allows technicians to identify gaps in communication logs or fragments of deleted data. A judge may view the act of deletion as spoliation of evidence, which can lead to adverse inference. This means the court could legally assume the deleted information was harmful to your case, regardless of what it actually contained. Let's look at the historical trends of financial disclosure. In the mid-20th century, hiding money was a matter of physical cash or secret bank accounts. By the 2010s, it moved into offshore accounts. In 2026, the battlefield is decentralized finance and digital assets. Case studies from 2024 and 2025 show a sharp increase in the use of blockchain analytics in family court. If a man has been transferring funds into cryptocurrency or non-fungible tokens, he must realize that while the assets are digital, the on-ramps and off-ramps, the points where he moved fiat currency from a traditional bank into a crypto exchange, are fully traceable. In 2026, the failure to disclose a digital wallet is often treated with the same severity as perjury. The step-by-step detail here is crucial. Modern discovery now includes requests for public keys and transaction histories. The goal for a man in this position is not to hide, but to ensure that these volatile assets are valued correctly. A Bitcoin balance worth $60,000 in January might be worth $40,000 by the time of the final decree. Without a contemporary valuation strategy, a man could end up buying out his spouse's share at an inflated peak price, leaving him with the subsequent loss. Furthermore, we must address the passive data generated by wearable technology. Imagine if a fitness tracker was used to challenge a man's health or lifestyle claims. In 2026, this is no longer a hypothetical scenario. If a party claims they are unable to work due to a physical ailment or chronic stress, but their wearable device shows they are running 5 miles a day or maintaining a resting heart rate that suggests high levels of physical activity, that data can be introduced to contest alimony or disability claims. The shift here is from what you say to what your devices report. The psychological profile built by algorithms is another 2026 phenomenon. Opposing counsels now use AI-driven sentiment analysis to scan years of text messages and emails. They aren't looking for one smoking gun message. They are looking for patterns of tone. If an algorithm identifies a pattern of aggressive language or dismissive communication over a 3-year period, it can be used to argue for a restricted communication order or to influence the appointment of a parenting coordinator. For men, this means the historical advice of "be careful what you write" has evolved into "assume every digital interaction is being read by a judge." The first 30 days also involved the critical task of digital decoupling. Historically, a man just had to worry about the house keys. In 2026, you have to consider shared iCloud accounts, family-linked Amazon accounts, and shared streaming services. If your spouse still has access to your location through a Find My feature or a shared family plan on a mobile network, your privacy is non-existent. Step 1 for any man in 2026 is a comprehensive audit of all shared digital permissions. This isn't about being deceptive. It's about establishing the necessary boundaries that the court expects during a legal separation. Consider the case of Thomas in Chicago. Thomas and his wife used a shared digital calendar for years. When the divorce started, Thomas forgot to remove his wife's access to his private calendar. She was able to track his meetings with legal counsel, his appointments with a therapist, and even his weekend travel plans. By the time Thomas realized the breach, the opposing side had already used that information to file preemptive motions, staying one step ahead of every move Thomas made. This demonstrates why the technological checklist is now just as important as the legal one. We are also seeing a change in how social proof is used. In the 1990s, you might bring a neighbor to court to testify that you are a good father. In 2026, you bring a data export of your parenting app usage. Apps like Our Family Wizard or Talking Parents have become the gold standard for evidence in U.S. family courts. These platforms create a non-editable record of every communication, every calendar change, and every expense reimbursement. For men who have historically felt that their efforts as a father were overlooked or misrepresented, these apps provide an objective, data-backed history of their involvement. Historical trends suggest that fathers who move their communication to these monitored platforms early in the process often see a reduction in he said, she said litigation, as the accountability provided by the app discourages false or exaggerated claims. The financial stakes of the digital perimeter also extend to lifestyle analysis. In 2026, forensic accountants don't just look at tax returns, they look at lifestyle data. If a man's reported income is $100,000 but his digital spending habits, tracked through apps like Venmo, DoorDash, and Uber, suggest a lifestyle of $200,000, the court can impute income to him. This means they will calculate child support or alimony based on what they think he is actually making, not what his W-2 says. The digital trail of a modern lifestyle is almost impossible to scrub, making total transparency the only viable path for men who want to avoid heavy judicial penalties. As we move through this century of change, it becomes clear that the man's help in 2026 is more about data management and emotional discipline than it is about aggressive legal posturing. The legal system has become a machine that consumes data and spits out a decree. If you feed the machine bad data, or if you allow your shadow data to be weaponized against you, the potential outcomes are significantly diminished. But there is a deeper, more invisible force at play in the 2026 divorce landscape. Beyond the apps, the smart homes, and the crypto wallets, there is the financial architecture of the modern family. We have moved from a world of shared wealth to a world of intertwined debt. In the next part, we will explore the debt trap divorce and how the credit score has become the new custody battle. We will look at how joint liabilities can keep you tethered to an ex-spouse for a decade after the papers are signed, and the specific steps you must take to achieve a true clean break in a high-interest rate economy. We will also examine why your individual credit identity is your most valuable asset during the transition, and how easily it can be sabotaged. In the early 20th century, Debt was a moral failing often kept in the shadows. If a couple in 1926 faced a financial crisis, it was usually tied to a physical ledger at a local bank or a merchant's credit line. Fast forward to 2026, and debt has become a structural component of the American household. For the modern man, the divorce process is no longer just about dividing what you own. It is increasingly about the strategic allocation of what you owe. In a high-interest rate economy, the way liabilities are handled can dictate a man's financial mobility for the next 20 years. This is the era of the debt-trap divorce, where a failure to decouple your credit identity can leave you legally single, but financially shackled to an ex-spouse. Imagine a man named Christopher in Charlotte, North Carolina. It is 2026, and Christopher is navigating a separation. Throughout his 15-year marriage, he and his wife operated on a model of joint credit. They have a joint mortgage with a 3.5% interest rate locked in years ago, 2 joint auto loans, and 3 shared credit cards. In Christopher's mind, the solution is simple. They will split the debt 50-50. However, the American legal system and the American credit system speak 2 different languages. While a divorce decree might state that Christopher's ex-wife is responsible for the balance on the silver SUV and the department store card, the original contract with the lenders remains unchanged. If she misses a payment 3 months after the divorce is finalized, it is Christopher's credit score that takes the hit. This is one of the most dangerous historical trends in modern family law: the gap between judicial orders and creditor rights. Case studies from 2025 and early 2026 highlight a rising phenomenon known as credit sabotage. This occurs when a disgruntled spouse intentionally maxes out joint accounts or stops making payments on shared liabilities during the litigation process. Because the accounts are joint, both parties are 100% liable for the full amount, regardless of who spent the money. For a man trying to secure a new apartment or a modest mortgage post-divorce, a sudden 30-point drop in his credit score can be catastrophic. The step-by-step detail for a man in this position involves an immediate freeze on all joint revolving credit lines the moment a separation is initiated. Historical trends show that men who wait until the final decree to address joint credit often find themselves facing thousands of dollars in surprise charges that the court may or may not credit back to them during the final asset division. We must also analyze the mortgage lock-in trap, a specific challenge of the 2026 economic climate. In 1950, a house was often paid off or held a very small balance. Today, the family home is usually the largest asset and the largest debt. If Christopher and his wife want to divorce, they face a brutal choice. If Christopher wants to keep the house and buy out his wife, he must typically refinance the mortgage to remove her name. In 2026, this means trading a 3% interest rate for a 7 or 8% rate. This move can double his monthly housing cost, potentially making the home unaffordable, even if he won it in the settlement. We are seeing a historical shift where men are forced to sell homes they intended to keep, simply because the cost of debt has outpaced the growth of their income. This is why equity buyouts now require a deep dive analysis of long-term carrying costs, rather than just a snapshot of current home value. Then there is the issue of student loan debt. In the mid-20th century, this was non-existent for the average couple. In 2026, it is a primary point of contention. If Christopher worked to support his wife through a master's degree or a medical residency, he might argue that her increased earning potential is a marital asset. Conversely, if she brought $100,000 in debt into the marriage, and they used marital funds to pay it down, Christopher may be entitled to a reimbursement alimony, or a larger share of the remaining assets. The data from U.S. family courts suggests that debt incurred for the benefit of one spouse's human capital is one of the most complex areas of modern litigation. It requires a man to produce a clear paper trail of every payment made toward that debt from joint funds. Furthermore, we are witnessing the rise of co-sign liability risks. Many men in their 40s and 50s have co-signed for their children's student loans or their first cars. In a divorce, these contingent liabilities are often overlooked. If the divorce decree doesn't specifically address who will hold the indemnity for these loans, a man can find himself legally required to pay for an adult child's debt, while his own retirement savings have been halved. The 2026 approach to a clean break involves an indemnification clause. This is a legal shield where one spouse agrees to hold the other harmless from a specific debt. If the creditor comes after Christopher for his ex-wife's debt, he can use this clause to sue her for reimbursement, though it is important to note that this does not stop the creditor from collecting from him in the first place. The individual credit identity is the new frontline of divorce help for men. Historically, a man's credit was simply the credit. Today, maintaining a separate financial existence is a survival skill. Step by step, this involves opening individual accounts, establishing a separate billing address, and monitoring credit reports weekly during the transition. The goal is to isolate your financial reputation from the turbulence of the dissolution. Potential outcomes for men who fail to do this include predatory lending traps, where they are forced to take high-interest personal loans to cover legal fees because their primary credit was decimated by a joint account default. Another 2026 trend is the tax liability trap. Many couples file joint tax returns during their marriage. If the IRS audits a return from 3 years ago and finds an error made by the spouse, both parties are generally jointly and severally liable. In 2026, men are increasingly utilizing the innocent spouse relief provisions of the tax code. This historical shift allows a man to argue that he should not be held responsible for a tax deficiency if he can prove he had no knowledge of the errors. However, the burden of proof is high. It requires a man to have been at least somewhat involved in the household finances, an area where many men historically defer to their wives, to their later detriment. As we look at the century of change, it's clear that the help men need has shifted from simple legal representation to holistic financial defense. You are not just fighting for your kids or your house. You are fighting for your ability to function in a debt-based society. The 2026 divorce landscape is unforgiving to the financially passive. Those who thrive are the ones who treat their credit score with the same level of protection they afford their physical safety. But there is an even more nuanced layer to this transition. While debt can chain you to the past, the earning power of the future is what defines your recovery. We are entering a phase where the career trajectory of a man is being scrutinized by courts in ways we have never seen before. In the next part, we will look at income imputation and the work-life balance paradox. We will explore how the system views a man who wants to downshift his career to spend more time with his kids, and why the court might legally forbid you from taking a lower-paying job. We will examine the professional goodwill trap, where the value of your business or your reputation is appraised like a piece of real estate, and how to protect the career you've spent a lifetime building. The concept of professional goodwill represents one of the most abstract, yet financially consequential shifts in American family law over the last century. In 1926, a man's career was his personal property. If he was a doctor, a lawyer, or a craftsman, his ability to earn was seen as an extension of his person, not a marital asset to be appraised and divided. However, as we move into 2026, the United States legal system has increasingly adopted the view that a career built during a marriage is a joint investment. This has given rise to the valuation of enterprise and professional goodwill, where the reputation of a man's business or his specific professional standing is assigned a dollar value that must be bought out by the spouse. Imagine a man named Stephen in Denver, Colorado. Stephen has spent the last 15 years building a specialized architectural firm. In the eyes of the court in 2026, the value of Stephen's firm isn't just the computers in the office or the balance in the business checking account. The court looks at the brand, the client list, and the recurring revenue elements that constitute goodwill. If a forensic appraiser determines that the business is worth $2 million, and $1.5 million of that is intangible goodwill developed during the marriage, Stephen may be ordered to pay his spouse $750,000 to keep the company he built. This is the professional goodwill trap. You are essentially being forced to buy back your own reputation. Historical trends show that courts distinguish between enterprise goodwill, which belongs to the business entity, and personal goodwill, which belongs to the individual. In 2026, the battle for men is proving that the success of their career is tied to their personal, non-transferable skills, rather than a sellable business asset. If Stephen can demonstrate that the firm's success is entirely dependent on his personal licenses and unique expertise, he may be able to shield a larger portion of that value from distribution. The step-by-step detail here involves hiring a specialized valuation expert who can perform a mumbling of the assets analysis, separating what the business is worth without the man at the helm. This leads us directly into the paradox of income imputation, a doctrine that has evolved significantly since the mid-20th century. Historically, if a man lost his job or chose to work less, his support obligations were often adjusted to reflect his actual income. In 2026, the standard has shifted to earning capacity. If a court determines that a man is underemployed, they can impute income to him. This means they will calculate child support and alimony based on what they think he should be making, not what he actually makes. Consider a case study of a man named Mark, a high-level software engineer in Silicon Valley. After 20 years of 80-hour weeks, Mark decides during his divorce that he wants to take a lower-paying role at a nonprofit to have more time for his children. In 2026, the court may view this as voluntary impoverishment. If the judge believes Mark is intentionally lowering his income to reduce his support payments, they can order him to pay based on his previous $300,000 salary, even if he is currently only earning $100,000. This creates a terrifying financial pincer move for men. The law encourages active fatherhood, yet the financial mechanics of the court may legally mandate that he continues to work the very hours that prevent him from being present. To navigate this, men in 2026 must provide a mountain of data. If you are changing careers or taking a pay cut, the step-by-step requirement is to prove that the move is for a legitimate reason, such as health, industry-wide layoffs, or the genuine necessity of a more flexible schedule for co-parenting. The data suggests that men who document their job search or provide medical evidence for career downshifting have far better potential outcomes than those who simply show up to court with a smaller paycheck. We also have to discuss the evolution of the executive bonus and the gig economy. A century ago, income was predictable. Today, a man's compensation might include base salary, annual bonuses, stock options, and side hustle revenue. In 2026, many states utilize a bonus cap or a percentage-based order for fluctuating income. This means if a man has a windfall year, a significant portion of that bonus is automatically diverted. Historical trends indicate that courts are moving away from fixed dollar amounts toward dynamic formulas that track a man's career trajectory in real time. This requires an unprecedented level of financial transparency and a constant adjustment of expectations. Furthermore, we are seeing the rise of the career sabotage defense. In the high-stakes environment of 2026, some men find their professional reputations targeted during the divorce. Since professional standing is a financial asset, any damage to that standing, such as calls to a human resources department or public social media allegations, can be viewed by the court as a dissipation of marital assets. If a spouse's actions lead to a man losing his job, the court may offset his alimony obligations or award him a larger share of the remaining assets as compensation for the loss of his career asset. This is a critical area where men must move from defense to offense, documenting every interaction that could impact their professional standing. The 2026 landscape also brings us to the concept of the double dip. This occurs when a court counts a man's business or professional practice as both a marital asset to be divided and a source of income for calculating alimony. For example, if Stephen's architectural firm is valued and divided, and then the profits from that same firm are used to calculate his monthly support payments, he is essentially paying twice on the same dollar. While many states have laws against this, the complexity of modern accounting often hides the double dip in plain sight. Men must ensure their legal team uses a cash flow analysis that strictly separates asset value from available income. As we examine this century of change, it becomes clear that a man's career is no longer a private sanctuary. It is a transparent, appraised, and heavily regulated engine of the divorce settlement. The professional identity you built to provide for your family is now the very thing the system uses to determine your post-divorce utility. The historical trend is a move toward viewing a man as a lifetime income-generating entity rather than a person with a job. However, even if you navigate the professional goodwill traps and the income imputation hurdles, there is a biological and social reality that the law is only just beginning to catch up with in 2026. This is the concept of the paternal burnout and the high-conflict custody cycle. While the laws have moved toward 50-50 shared parenting, the actual execution of that life requires a radical shift in how a man manages his time, his home, and his mental health. In the next part, we are going to dive into the tactical home front. We will explore how to build a residence that the court views as a primary home rather than a visitor's pad, the specific data points that prove parental involvement, and how to survive the parenting evaluation without losing your mind or your career. We will also look at the rising trend of bird nesting and whether it is a viable solution or a psychological trap for the modern father. Establishing the tactical home front in 2026 is a far cry from the bachelor pad stereotypes of the 1970s. A century ago, a divorced father was often expected to reside in a transient space, a hotel or a small apartment, while the mother and children remained in the family homestead. The law viewed the father as a visitor, and his living conditions reflected that secondary status. Today, if a man wants to secure a 50-50 custody arrangement, his residence must be more than a place to sleep. It must be a fully functional mirror of the family home. In the eyes of a 2026 custody evaluator, there is no such thing as a visiting parent, only a co-parent with a secondary relation that must meet the same rigorous standards of stability, safety, and nurturance as the primary one. Imagine a man named Daniel in Nashville, Tennessee. Daniel is in the middle of a contested custody battle. He moves into a 2-bedroom apartment near his office. In 1996, this would have been considered more than adequate. In 2026, a court-appointed guardian ad litem or a custody evaluator will walk through that apartment with a digital checklist. They are looking for specific indicators of intentional fatherhood. Does each child have a dedicated room? Or are they sharing a couch? Is the pantry stocked with the specific nutritional needs of the children? Or is it filled with takeout containers? Are there age-appropriate toys, books, and a dedicated workspace for school projects? Daniel must realize that in the modern era, the home is a piece of evidence. Every square foot is being appraised for its ability to support a child's routine. Historical trends show a massive shift in how courts evaluate the physical environment. We have moved from the maternal preference era to a gender-neutral capacity assessment. Step by step, a man in 2026 needs to document his home setup before the first home visit. This includes proof of proximity to the children's school, safety certifications for the residents, and even a demonstrated understanding of the neighborhood's resources, such as parks and pediatricians. Case studies from 2024 and 2025 suggest that fathers who proactively create a child-centric environment, complete with established routines and documented safety measures, are significantly more likely to have their 50-50 parenting time requests granted without a prolonged legal fight. This brings us to the rise of bird nesting. This is a 2026 trend where the children stay in the family home, while the parents rotate in and out according to the custody schedule. On the surface, it seems like the ultimate solution for stability. The kids don't have to live out of a suitcase, and the family home remains intact. However, for many men, bird nesting becomes a psychological and financial trap. Imagine Daniel again. During his week in the nest, he is responsible for the mortgage, the maintenance, and the grocery bills. During his week out, he is paying for a secondary studio apartment. He is effectively funding 2.5 households on a single income. Furthermore, bird nesting often blurs the emotional boundaries necessary for a clean break. If Daniel returns to the nest and finds his ex-spouse hasn't cleaned the kitchen or has rearranged his personal items, the conflict reignites instantly. Data from family therapists in 2026 indicates that while bird nesting can work as a short-term transitional tool for 3 to 6 months, long-term bird nesting often leads to a phenomenon called parental enmeshment, where neither parent can fully move on with their lives. Men must be extremely cautious before agreeing to a nesting arrangement, ensuring there is an ironclad exit strategy and a clear division of financial responsibilities in the temporary agreement. To survive a 2026 parenting evaluation, a man must understand the evolution of the clinical psychologist's role in divorce. A century ago, your character was judged by your standing in the community or your church. Today, it is judged by standardized psychological testing and behavioral observation. A modern evaluation might involve the MMPI-3, Minnesota Multiphasic Personality Inventory, or the Rorschach, but more importantly, it involves the evaluator watching you interact with your children. The key for a man today is not to perform for the evaluator, but to demonstrate a consistent, data-backed history of involvement. In 2026, this means producing the digital paper trail we discussed earlier. If the evaluator asks about your involvement in education, you don't just say you are involved. You show the login history for the school's parent portal. If they ask about medical care, you show the calendar entries for the last 3 years of dental and wellness checkups. The move from anecdotal evidence to hard data is the most significant historical trend in custody help for men. The potential outcome of a successful evaluation is a court order that recognizes you as a primary caregiver, which in turn significantly impacts the calculation of child support. In many jurisdictions, the more overnights a father has, the lower his monthly transfer payment becomes, reflecting the direct costs he incurs while the children are in his care. We must also address the tactical importance of the first 90 days of a 50-50th schedule. This is often a trial period monitored by the court. During this time, any slip-up, a late pickup from soccer, a missed homework assignment, or a heated text message, can be used to argue that the schedule is not in the best interest of the child. Men in 2026 are increasingly using domestic management software to stay organized. This isn't just about being a tech-savvy dad. It's about building a defensive wall against allegations of incompetence. Consider a case study from Illinois in 2025 where a father was able to defeat a motion to reduce his parenting time specifically because he had a digital log of every meal, every medication dose, and every school interaction. The mother had argued he was overwhelmed and unable to manage the children's complex schedules. The father's data proved that not only was he managing, but the children's grades had actually improved during his weeks of custody. This is the 2026 reality. The court respects a man who manages his household with the same professional rigor he applies to his career. However, the tactical home front isn't just about the physical space or the digital logs. It's about the emotional climate. In 2026, parental alienation is a term that is frequently used but rarely understood. Historically, a parent could say almost anything to a child about the other parent without legal consequence. In the modern era, judges are increasingly sensitive to the gatekeeping behavior of a primary parent. If a man can document that he is being consistently excluded from school events, or that his communication with the children is being monitored or restricted, he can file for a motion for enforcement, or even a change of custody, based on interference with parental rights. The strategy for men is radical transparency. If you are being blocked, do not retaliate in kind. Instead, document the block and continue to show up. In 2026, the parent who is seen as the facilitator of the other parent's relationship with the child is often the one who receives the most favorable treatment from the court. The century of change has taken us from a world where the father had to fight to get in the door, to a world where his presence is expected, provided he can prove he is a competent, organized, and emotionally stable force. As we stabilize the home front and secure the 50-50 schedule, we run into a different kind of boundary, one that isn't made of walls or schedules, but of digital algorithms and social circles. The modern man doesn't just divorce a spouse, he divorces a shared social ecosystem. In the next part, we will explore the social and reputational recovery. We will look at how to handle cancel culture within your local community, how to manage the mutual friend fallout, and the specific 2026 protocols for re-entering the dating market while litigation is still active. We will also examine the post-divorce identity crisis, and why your digital reputation might need a total overhaul before you can truly start your second act. The social and reputational recovery of a man in 2026 is often more complex than the legal battle itself. A century ago, the social fallout of a divorce was dictated by local gossip and a slow-moving reputation economy centered around the town square or the neighborhood church. If a man in 1926 was perceived as the cause of a marital breakdown, the social consequences were immediate but geographically contained. In 2026, the neighborhood is global, and the town square has been replaced by social media algorithms that have a long memory and a wide reach. For the modern man, the end of a marriage often triggers a secondary crisis: the fragmentation of his digital and social identity. Imagine a man named Gregory in Atlanta, Georgia. It is 2026, and Gregory's divorce has just become public knowledge within his professional and social circles. In the 1990s, Gregory might have worried about which friends would side with him over coffee. In 2026, he is dealing with a digital social ecosystem where his mutual friends are being served targeted content, and his professional LinkedIn network is witnessing subtle shifts in his profile. Gregory's first challenge is the mutual friend fallout. Data from social scientists in 2025 indicates that the average American couple shares approximately 70% of their social circle. When the divorce filing hits, those shared connections often feel pressured to choose a side, even if no one asks them to. This choice is frequently influenced by who controls the narrative on social media first. Historical trends show that men often take a silent approach to social fallout, believing that if they don't talk about the divorce, it isn't happening. However, in 2026, silence is often interpreted as a vacuum that the other party's narrative will inevitably fill. Gregory must navigate the social cancel culture within his own community. This isn't about being a celebrity. It's about the micro-communities of the PTA, the local gym, or the country club. If a man is accused of financial abandonment or lack of involvement during the heat of a legal battle, those accusations can travel through digital group chats in seconds. The potential outcome for a man who ignores his social reputation is a localized form of ostracization that can impact his mental health and his career opportunities. Step by step, the 2026 protocol for reputational defense starts with a digital audit. You must look at your social media presence through the lens of a stranger. In the mid-20th century, your family photos lived in a physical album. Today, they are a public record of your past. A man in Gregory's position needs to decide whether to archive, delete, or maintain his digital history. The historical trend in 2026 is toward clean slating, where men create a clear demarcation between their married era and their new act. This isn't about erasing the past, but about signaling to the world and the algorithms that a new chapter has begun. We must also address the dating market re-entry. While litigation is still active, this is a minefield that didn't exist in 1926. In the era of the app, your digital identity on a dating platform can be harvested as evidence in a courtroom. Imagine if Gregory creates a profile on a dating app in 2026 while his child support and alimony figures are still being debated. If he describes himself as living a high-flying lifestyle or traveling the world to attract matches, those screenshots will be in his wife's attorney's hands by Monday morning. U.S. case studies from 2024 and 2025 show a sharp increase in app-based evidence, where a man's self-representation on a dating profile is used to argue that he has more disposable income than he claimed in his financial affidavits. The 2026 dating protocol for men in litigation is one of deep discretion. The historical trend is moving away from the rebound and toward the rebuild. Men are increasingly advised to stay off public dating platforms until the temporary orders are finalized. If Gregory does choose to date, he must understand that in the era of Google Lens and background check apps, any person he meets can find his divorce filing and his financial history within minutes. Transparency is no longer a choice. It is a mechanical necessity of the information age. Furthermore, we are seeing the post-divorce identity crisis hit men harder in 2026 because of the collapse of traditional male social structures. A century ago, men had lodges, social clubs, and labor unions that provided a secondary identity outside of the home. In 2026, many men find that their entire identity was built around the family unit. When that unit dissolves, they are left with a vacuum. This is where the digital reputation overhaul becomes essential. A man must intentionally curate a new set of hobbies, interests, and social connections. Data suggests that men who join men's divorce recovery groups or fatherhood advocacy networks in 2026 see a 40% faster rate of psychological recovery than those who try to white-knuckle the transition alone. Let's look at a case study of a man named Anthony in Chicago. Anthony was a high-level executive whose social life was entirely intertwined with his wife's charity work. When they divorced in 2025, Anthony found himself excluded from the very events that fueled his professional networking. His 2026 recovery involved a strategic pivot. He started a podcast about his industry and joined a CrossFit community where no one knew his ex-spouse. He essentially built a social firewall. This move protected his professional interests and allowed him to define himself on his own terms. Another critical aspect of the 2026 landscape is digital legacy management for children. In the 1950s, kids might overhear a whispered conversation. In 2026, children are digital natives who can search their parents' names on social media. A man has a moral and strategic duty to ensure that the digital footprint he leaves during his divorce is one he would be proud for his children to see in 10 years. This means avoiding the angry rant or the subtweet aimed at an ex-spouse. The historical data shows that children of high-conflict digital divorces experience higher rates of anxiety. By maintaining a dignified digital presence, a man is not just protecting his reputation. He is protecting his children's mental health. The century of change has brought us to a point where your reputation is a quantifiable asset. In the mid-20th century, you could move to a new town and start over. In 2026, your digital shadow follows you everywhere. This requires a man to be his own PR manager. You have to be proactive about who you are and what you stand for. The potential outcomes of a well-managed reputation include better professional opportunities, a healthier social life, and a more stable environment for your children. But there is one final hurdle that is often the most difficult to clear. It is the internal audit. Beyond what the neighbors think and what the apps say, there is the question of how the modern man views himself when the dust settles. We have covered the legal, the financial, the digital, and the social. Now we must face the psychological architecture of the 2026 divorce. In the next part, we will explore the stoic transition. We will look at how to manage the grief-to-growth pipeline, the data behind male mental health in the first 2 years post-divorce, and why your post-divorce wellness plan is the most important document you will ever draft. We will also examine the second marriage trap, and why the data suggests you should wait longer than you think before ever saying "I do" again. The psychological architecture of a man in 2026 is undergoing a quiet but profound reconstruction. A century ago, the prevailing social script for a divorced man was one of stoic repression. In 1926, a man was expected to bury his emotional upheaval under a layer of professional duty, and perhaps a new suit. There was no vocabulary for the grief of losing daily access to his children or the displacement of his domestic identity. However, as we navigate the mid-2020s, the United States is witnessing a historical trend where mental health is no longer a peripheral concern, but a core component of a successful legal and life strategy. The modern man must transition from the old model of white-knuckling through the pain to a data-driven wellness plan that ensures he remains functional, clear-headed, and resilient. Imagine a man named Julian in Philadelphia. It is 2026, and Julian has just signed his final decree. For the last 18 months, Julian has been in survival mode, reacting to legal motions and managing his work. Now that the silence has set in, Julian faces the grief-to-growth pipeline. Historically, men are more likely than women to experience a sharp decline in physical health post-divorce, with data from 2024 indicating a 20% increase in the risk of cardiovascular events and a significant rise in social isolation. For Julian, the psychological architecture of his recovery depends on how he handles the first 24 months of his second act. The first step in this psychological masterclass is the recognition of the divorce fog. In the mid-20th century, this was often dismissed as temporary blue feelings. In 2026, cognitive scientists describe it as a state of chronic high cortisol stress that impairs the prefrontal cortex, the part of the brain responsible for decision-making and impulse control. A man in Julian's position might find himself making impulsive financial choices or engaging in high-conflict digital exchanges because his brain is stuck in a fight-or-flight loop. The step-by-step detail for managing this involves what experts call the stoic transition. This isn't about suppressing emotion. It is about the clinical application of logic to emotional data. Case studies from 2025 show that men who implement a formal post-divorce wellness plan, incorporating specific metrics for sleep, physical activity, and social interaction, recover their cognitive function 30% faster than those who do not. Julian's wellness plan isn't a vague set of goals. It is a document. It includes a schedule for regular therapy, a commitment to a community-based hobby that requires physical presence, and a strict digital sunset to prevent late-night doom-scrolling of his ex-spouse's social media. The historical trend in 2026 is the movement toward biohacking for resilience, where men use technology to monitor their stress levels and intervene before an emotional spike leads to a legal or social setback. Furthermore, we must address the second marriage trap. Historically, men have been much quicker to remarry than women, often entering a new legal union within 3 years of a divorce. In the 1950s, this was seen as a sign of stability. In 2026, the data tells a different story. The divorce rate for second marriages in the United States currently hovers around 60 to 67%. The psychological reason is often transference, the act of bringing the unhealed wounds and dysfunctional patterns of the first marriage into the second. Imagine if Julian, seeking to escape the loneliness of his new apartment, rushes into a marriage with a woman he met 6 months ago. By 2028, he could be facing a second divorce, this time with even more complex asset division and potentially more child support obligations. The 2026 data suggests that a man should wait significantly longer than he thinks, often a minimum of 2 to 4 years, before legally intertwining his life with another person. This period is not just for dating around, it is for the internal audit. This involves a deep dive into the historical trends of his own relationships. Why did the first marriage fail? What were the red flags he ignored? Without this audit, the potential outcomes for a second marriage are statistically unfavorable. Men are increasingly utilizing relationship forensics, sometimes working with coaches or psychologists to deconstruct their past patterns so they don't repeat them. We also have to look at the concept of fatherhood identity 2.0. A century ago, a man's identity as a father was tied to his role as the provider. If the marriage ended, that identity was often stripped away, leaving the man in a state of ambiguous loss. The grief of losing someone who is still alive. In 2026, the shift toward shared parenting means Julian is still a primary father, but he is a father in a different context. He is now the sole executive of his household during weeks of custody. This requires a psychological pivot from being the fun dad, or the secondary parent, to being a fully integrated domestic manager. The data shows that men who embrace this domestic autonomy report higher levels of life satisfaction and a stronger bond with their children than those who try to maintain a visitor mindset. There is also the matter of the social mirror. In the 1920s, a man's reflection was found in his community's eyes. In 2026, it is found in his screen. The psychological toll of being unfollowed or blocked can trigger a sense of social death. Julian must learn to decouple his self-worth from his digital status. This involves algorithm management, intentionally feeding his social media feeds with content focused on growth, health, and career rather than grievance or nostalgia. Historical trends in 2026 indicate that the grievance industry, online spaces that encourage men to stay angry, actually slows down the recovery process by keeping the brain in a state of perpetual high-conflict arousal. The Stoic transition also applies to the concept of forgiveness, not as a moral imperative, but as a strategic release. In the mid-20th century, holding a grudge was often seen as a matter of honor. In 2026, holding a grudge is seen as a tax on your future. Every ounce of emotional energy Julian spends being angry at his ex-spouse is an ounce of energy he isn't spending on his career, his kids, or his own health. The goal of the 2026 man is emotional neutrality. When Julian can look at a text from his ex-wife and feel the same level of emotional engagement as he does when reading a weather report, he has officially completed the transition. This leads us to the final piece of the psychological architecture, the vision quest. A century ago, a man's life path was largely predetermined by his social class and his trade. In 2026, the post-divorce man has an unprecedented level of freedom, which can be both a blessing and a curse. Without a clear vision for his future, Julian risks drifting into a state of hedonic adaptation, chasing short-term pleasures that leave him feeling empty. The successful 2026 transition involves setting legacy goals, long-term objectives that define what kind of man he wants to be 10, 20, or 30 years from now. We have explored the legal battle, the financial maze, the digital perimeter, and the psychological reconstruction. We have moved from the 1920s model of a man as a rigid provider to the 2026 model of a man as a dynamic, resilient, and data-informed individual. But as Julian begins to rebuild his life, he must face one of the most practical and immediate challenges of his new reality: the logistical mastery of the long-term co-parenting relationship. The legal papers are signed, the emotions are stabilizing, but the next 15 years of his life will be defined by how he manages the microtransactions of shared life. In the next part, we will dive into the co-parenting CEO. We will look at the specific protocols for navigating school events, holidays, and new partners without triggering a legal relapse. We will examine the boundary defense system and why your ability to say no politely, firmly, and legally is your most important communication skill. We will also look at the rising trend of co-parenting mediation and how to keep your life out of the courtroom forever. Becoming the co-parenting CEO in 2026 requires a radical departure from the combative instincts of the past century. In 1926, the concept of co-parenting barely existed in the legal or social lexicon of the United States. A man was either the head of a household or he was an outsider. If a marriage ended, the lines of communication were often severed, and the children became the silent witnesses to a Cold War. Fast forward to 2026, and the expectation has inverted. The U.S. family court system now treats co-parenting as a professional obligation. For the modern man, this means managing his relationship with an ex-spouse with the same strategic distance, emotional control, and documentation rigor that he would apply to a high-stakes business partnership. Imagine a man named Marcus in Phoenix, Arizona. Marcus has been divorced for 2 years and shares 50-50 custody of his 2 young children. In the old model of divorce, Marcus might have engaged in verbal arguments at the front door during every exchange. In 2026, Marcus operates under the boundary defense system. This system is built on the historical trend of moving communication away from the personal and into the administrative. Marcus does not use personal text messages or phone calls to discuss schedule changes or school issues. Instead, he uses a dedicated parenting portal. Every request, every expense, and every medical update is a time-stamped record. This shift is critical because in 2026, the person who keeps the cleanest records often holds the most leverage in future mediation. The first protocol of the co-parenting CEO is the management of the microtransaction. These are the small, daily interactions that can either stabilize a life or trigger a legal relapse. Consider the case study of a man in Florida who faced a motion for contempt because he was consistently 5 minutes late for exchanges. In the mid-20th century, a 5-minute delay was a non-event. In the era of the 2026 digital schedule, it is a data point used to argue that Marcus is unreliable or disrespectful of the court-ordered parenting plan. The step-by-step detail here involves utilizing GPS-stamped check-ins at exchange locations. If Marcus arrives at the designated park for an exchange, he logs his presence in the parenting app. This provides an irrefutable history of compliance that effectively silences any future allegations of tardiness. We must also analyze the school event protocol. Historically, school functions were a primary flashpoint for post-divorce conflict. In 2026, the data shows that high conflict visibility, arguing in public or forcing school staff to mediate between parents, is one of the fastest ways to lose favor with the judge. Marcus follows a parallel presence strategy. He checks the school calendar months in advance, logs his intention to attend, and ensures he has his own copy of all school communications. He does not rely on his ex-spouse for information, and he does not engage in personal conversation at the event. He is there for the child, acting as a silent, supportive executive. This professionalization of parenting protects the child's environment and prevents the creation of evidence that could be used to restrict Marcus's access. Then there is the issue of new partners. This is perhaps the most volatile area of co-parenting in 2026. A century ago, a new spouse was simply accepted as the new step-parent. In the current legal climate, the introduction of a new partner can trigger right of first refusal clauses or requests for lifestyle evaluations. Marcus understands that his private life can impact his legal standing. The historical trend in U.S. family law is moving toward cooling-off periods. Many 2026 parenting plans include a clause stating that a new romantic partner cannot be introduced to the children until the relationship has lasted at least 6 to 12 months. Step by step, Marcus manages this by keeping his dating life entirely separate from his parenting time until he is ready to commit. He documents the timeline of his relationship to prove compliance with the order, ensuring that a new relationship doesn't become a liability in his co-parenting balance sheet. We are also seeing the rise of co-parenting mediation as a permanent fixture. In the 1980s, you went to mediation once to settle the divorce. In 2026, parenting coordinators or special masters are often assigned to oversee the long-term execution of the plan. These are professionals who act as a buffer between parents. If Marcus and his ex-spouse cannot agree on which summer camp the children should attend, they don't go to court, they go to their coordinator. The data from U.S. family courts suggests that using these mediators reduces the burn rate of legal fees by 60%. The strategy for the modern man is to be the most reasonable person in the room. By consistently proposing logical, child-centered solutions, Marcus builds a reputation with the coordinator that carries significant weight if a major dispute ever arises. Furthermore, we must address the boundary defense of financial obligations. In the mid-1900s, child support was often a fixed, stagnant number. In 2026, it is a dynamic calculation involving Section 7, or extraordinary expenses. These include things like private school tuition, high-level sports, and medical copays. Marcus treats these like corporate invoices. He never pays in cash. He never pays based on a verbal request. Every expense must be supported by an original receipt and submitted through the designated portal. This prevents the financial creep that often happens when an ex-spouse treats child support as a starting point rather than a total obligation. Historical trends show that men who do not strictly enforce the documentation of these extras often end up paying 15 to 20% more per year in undocumented convenience fees. The potential outcomes for a man who masters the CEO mindset are profound. Instead of a decade of grinding litigation, he achieves a state of functional detachment. He has a life that is truly his own, unburdened by the emotional volatility of his previous marriage. His children grow up seeing a father who is organized, present, and respectful, even in the face of conflict. This is the ultimate goal of the century of change, moving from the father as a funder to the father as a founder of a new, stable, and independent family structure. However, as Marcus builds this new life, he must be aware of the long-tail legal risks. In the 2026 economy, assets and laws continue to shift. A settlement that looks fair today might become a burden tomorrow if tax laws change, or if a business valuation fluctuates. The final phase of the masterclass isn't about the end of the divorce. It's about the infinite game of post-divorce maintenance. We have mastered the home, the money, the data, and the children. But how do you bulletproof your future against the unexpected? In the final part of this series, we will explore the sentinel phase. We will look at the protocols for periodic review of your settlement, how to handle the empty nest transition when child support finally stops, and the legacy of the modern man. We will examine why the 2026 divorce isn't an ending, but a pivot point to a more intentional, resilient, and powerful version of yourself. We will close the loop on the century of change and give you the final blueprint for long-term peace and prosperity. The sentinel phase represents the final evolution of the modern man in the 2026 divorce landscape. This is the period of long-term maintenance where the initial fires of litigation have been extinguished, and the focus shifts toward the preservation of peace, the protection of assets, and the cultivation of a lasting legacy. A century ago, in 1926, the finality of a divorce decree was almost absolute because the financial and social structures of the time were static. If a man was ordered to pay a certain amount, that was typically the end of the conversation until the children reached the age of majority. In 2026, the legal and economic environments are fluid, characterized by rapid shifts in tax law, volatile markets, and changing judicial philosophies. To survive and thrive in this era, a man must adopt a sentinel mindset, constantly scanning the horizon for shifts that could impact his stability. Imagine a man named Richard in Denver. It is 2026, and Richard has been divorced for 5 years. He has successfully navigated the co-parenting CEO phase, and his children are now entering their teenage years. In the old model, Richard might have put his divorce papers in a drawer and never looked at them again. But Richard knows that the sentinel phase requires a periodic review of his settlement. Historical trends in the United States show that as the economy fluctuates, the reasonableness of a decade-old settlement can vanish. For example, if Richard's income has significantly decreased due to industry automation, or conversely, if his ex-spouse has experienced a massive financial windfall, the original support orders may no longer reflect the current reality. The step-by-step detail for the periodic review involves a 3-year audit. Every 36 months, Richard consults with a financial professional to compare his current net worth and cash flow against the assumptions made during the divorce. This isn't about looking for a fight. It is about right-sizing his obligations. In 2026, many states allow for a material change in circumstances to trigger a modification of support. By staying ahead of this data, Richard can proactively seek a mediation to adjust payments downward if the numbers support it, rather than waiting for a financial crisis to force his hand. Potential outcomes for men who ignore this review include years of overpayment that can never be recovered, as most jurisdictions do not allow for the retroactive reimbursement of support. We must also analyze the empty nest transition. This is a critical historical shift in the divorce life cycle. In the mid-20th century, child support simply stopped when a child turned 18 or graduated high school. In 2026, the lines are blurred by the cost of higher education and the failure to launch phenomenon. Many modern divorce decrees include provisions for post-secondary educational support, often referred to as college contributions. Richard must be prepared for the sunset clause of his child support. This is the point where his monthly transfer payments end, but his direct support for his children's adulthood begins. Historical data suggests that men who do not plan for the specific date when child support terminates often find themselves in a spending trap, where they have lifestyle crept their own expenses to match their previous income. The Sentinel Blueprint requires Richard to treat the end of child support as a forced savings event. Instead of absorbing that extra cash into his daily budget, he redirects it immediately into his retirement catch-up funds. This move, executed over the final 5 years of a child's dependency, can be the difference between a strained retirement and total financial independence. Furthermore, we must address the legacy of the modern father. A century ago, a divorced father was often a cautionary tale or a ghost in the family history. In 2026, the data shows that children of 50-50 shared parenting arrangements view their fathers as primary pillars of their lives. Richard's legacy is not just the money he leaves behind, but the parental presence he maintained through the high-conflict years. This involves the documentation of history. In 2026, men are increasingly creating digital archives for their children, collections of photos, letters, and shared memories that were intentionally preserved outside of the marital home. This emotional estate planning ensures that the children have a complete narrative of their heritage, regardless of the parents' relationship status. Consider a case study from 2025 where a father's meticulous record-keeping of shared vacations and school projects became the foundation for his children's sense of identity after they reached adulthood. They didn't remember the legal motions, they remembered the consistency. This is the ultimate goal of the sentinel phase, the transition from being a litigant to being a patriarch. It is the understanding that the divorce was a chapter, not the book. The 2026 landscape also requires a man to manage his estate planning with extreme precision. Historically, a man might forget to change the beneficiary on a life insurance policy or a 401k. In the digital age, these oversights are common and costly. Richard must conduct a beneficiary audit every time he has a major life change. U.S. case studies are filled with stories of ex-spouses receiving massive payouts because a man failed to update a single form. The step-by-step detail here involves the use of a revocable living trust, which allows Richard to keep his assets out of probate and ensures that his children, and only his children, are the beneficiaries of his life's work. We also have to look at the psychological legacy. A man who has survived a century of change and divorce help is a man who has mastered his emotions. Richard's legacy to his children is the example of how a man handles adversity. By refusing to engage in the War of the Roses, and instead choosing the path of the smarter settlement, Richard has taught his children about boundaries, respect, and resilience. This is the invisible inheritance that often proves more valuable than the physical assets. As we conclude this deep dive masterclass, we must look at the final blueprint for the U.S. man. We have moved from 1920 to 2026, from moral fault to mathematical equity, from visitor to co-parent, and from repressed to resilient. The help available today is not just about a better lawyer. It is about a better system of living. You are now equipped with the historical context to understand why the laws are the way they are, and the tactical data to navigate them effectively. But remember, the landscape never stops shifting. Even as you settle into the peace of the sentinel phase, new technologies like AI-driven judicial forecasting and virtual property division are beginning to emerge on the 2027 horizon. The successful man is the one who remains a student of the system. The loop is closed on the conflict, but the loop of your growth remains open. You have the tools, the data, and the history. Now it is time to build the future you deserve. The journey doesn't end here. While we have covered the macro trends of the last 100 years, there is a specific high-stakes area of the 2026 economy that is starting to impact divorce settlements in a way we have never seen before. It involves the tokenization of real estate and how fractional ownership is complicating the family home division. In our next deep dive series, we will look at the future of marital assets and how to protect your stake in a world where everything is being digitized. Stay vigilant, stay informed, and stay in the lead.